Good morning, everybody. Welcome to our webinar this morning. I'm Charlotte Sloan. I'm a Senior Associate in the Gatwick Employment Team. I'm joined with my colleague Sarah Burke, a Senior Associate in the Southampton team. Today, we're delighted that so many of you have joined us for our session, where we're going to be looking at the latest developments in respect of employment law, which have been impacted by the coronavirus pandemic. As always, we've got a fairly packed session to get through. We're going to be covering various things today. In particular, we'll be looking at furlough and the latest developments there, including in respect of flexible furlough. We're also going to be looking at health and safety, risk assessments, returning to the workplace, and what you need to be thinking about in that regard. And there's quite a lot to think about there. We're also going to be covering off various points in respect of varying hours, varying terms for your employees, and also redundancies. We know lots of you will be in a position where, unfortunately, you may need to be thinking about redundancies. We'll be covering off some top tips to think about there, including some of the nuances that you need to consider that have changed as a result of the coronavirus situation. And finally, we're going to be looking at agile and flexible working. Lots of people continuing to work from home. People still needing to be fairly flexible in respect to their work arrangements. We're going to be talking about various things that you can think about there. So I hope that helps give you an overview as to what we're going to be thinking about. We've got a slide in front of you there which will cover off all of those things. We're going to click through the slides as we go along, and you will have the slides available to you to access as well separately after this webinar. We've got a question and answer box at the right hand side of your screen. So as we go along, please do post your questions. We've got some time towards the end of the webinar to answer those. So please post them there, and we will be collating them. My colleague Laura Ludlam, who's on this webinar today, is going to be collating them for me and Sarah. We'll do our best to answer as many of those as possible at the end of the session. Please do remember to leave your name and contact details, however. So if we don't answer your question, we do promise to give you a call back and answer those questions with you after today's webinar. So make sure you do leave those contact details. One more thing just to mention is, obviously, we are delighted that so many of you have joined us virtually for this session. In doing it virtually, we can't see your lovely faces and we can't speak to you about your feedback face to face. So it's really important that we do get your feedback via our feedback form. That feedback form is accessible via the question and answer facility. So if you could answer the feedback form there, that'd be really helpful. That's available throughout this session, and we'll remind you again towards the end of the session that that's there. Without further ado, I will continue with the session and get through the first bit, which is in relation to furlough and the latest developments. So as I'm sure you all know, furlough scheme was live from the 1st of March until the 31st of October 2020, but it is ending at the end of October. Now, there is pressure from certain sectors that are particularly affected by the pandemic to extend furlough beyond that. At the moment, there's no indication that that will happen, but please watch this space because there may be some further news on that. We do have a coronavirus hub where we post our latest updates. So as soon as we've got any news in respect of any changes to that position, we will let you know via that. So if you sign up to that hub via our website, you can get access to the latest developments. Now, in respect to the scheme as we currently know it, it closed to anyone who wasn't furloughed for a full 3-week period between the 1st of March and the 30th of June. There is an exception in respect of those taking family-related leave and returning from that leave. So if you've got those returners from maternity leave or shared parental leave, you might want to get some separate advice as to furloughing them as a new arrangement, because that is possible. Now that is the end of the furlough scheme, the old scheme. What's replaced it from the 1st of July is the flexible furlough scheme. So that is where you've got more flexibility, as the name implies, in respect of what you do in respect of your employees. So that's something you may be thinking about using going forward if you've used furlough previously. So we go on to the next slide, just going to cover that off briefly. So essentially what it is, if you've got somebody who previously worked 5 days per week and you need them back 2 days per week, you can use the flexible furlough scheme for that. So you can have them being paid for the 2 days a week, which you can accommodate them for. And for the remaining 3 days, they can be on furlough. Now, you do need to put in place a new agreement in respect of that flexible furlough arrangement. We'd recommend a separate, different document to the letter or document you originally used when you put people on furlough in the first instance, because there are some differences. So do get some advice, get a template Word, and if you haven't got one already, we've been helping lots of clients with that, so please get in touch with us if we can help you at all. And that is really important to document the flexible furlough arrangement. So please use that. It's quite a good option, flexible furlough, in terms of it allows you to gradually get people back to the workplace. Though you may need to be looking at continuing to furlough people full time if you're not yet in that position. One more thing I was just going to say in relation to furlough there is just, if you're, I know a number of you on this call today are in the public sector. In that situation, there are more difficulties in terms of claiming furlough from the government scheme. There's quite complex rules in that regard. So if you are in that bracket, it may be worth getting some advice before you put people on furlough or use the flexible furlough arrangements. We know from clients, we know from contacts that the government are already querying furlough claims from the public sector. So you just need to be prepared to explain that situation and how you are able to do that in accordance with the rules. So do get some advice if you're unsure. Few nuances in respect of flexible furlough that I just wanted to make you aware of on the slide there is that the number of employees furloughed must not exceed the maximum number of employees claimed for under the old scheme, though that excludes returning parents. So what that means is, say you've been using furlough on rotation, so you've got 20 employees on furlough, but you've been having only 10 employees at a time actually furloughed because you've been rotating it, 10 working, 10 on furlough. Under flexible furlough, you can still only use a maximum of 10 people on that scheme. So just be aware of that, because that might cause some difficulties for you in terms of the numbers that you can put onto flexible furlough. Another difference in respect of the new scheme is that previously you had to be on furlough for a minimum of 3 weeks. There's no minimum time record period required under the flexible furlough arrangements. So it doesn't need to be for a minimum of 3 weeks. And there are some differences in terms of how you claim for the flexible furlough, so just be aware of that. Again, if you're not sure, get some advice on it, and there are some very detailed government guidance in respect of how you make the claims and the claim periods that you can claim for, and I've just put some of the detail on that briefly on this slide. Move on to the next slide there. Something else that you just need to be aware of, which I'm sure most of you are, is in respect of the changes to the financing of furlough. Previously, the government were contributing the 80% towards the furlough scheme. So essentially, they were covering the cost of you furloughing, because all you had to pay in respect of salary was 80% of pay, and it's subject to that cap of £2,500. Now, going forward, that is changing. So from the 1st of August, it has already changed in respect of the fact that employers need to meet the cost of the employer national insurance and pension contributions. From the 1st of September, it's changing again, and the government are only going to pay the 70% of the furloughed wages, subject to a cap, which is reducing. And employers have to contribute the remaining 10%. And then from October the 1st, the employer has to contribute 20%. So there is going to be more of a cost to the employer in using the furlough scheme. And that's likely to impact as to your decisions as to whether you can continue to access that and whether actually it is viable, whether you do have to make other decisions there. So in order to work out whether you can continue to use it and what the other options might be, you then need to think about the other schemes that the government have recently announced which are available to you. So we move over to the next slide, there on the next slide there. First one to mention is the job retention bonus of £1,000 per employee. That was something that was fairly recently announced, that the employer can claim that in respect of every furloughed employee who meets the conditions there. There are some rules and conditions attached to it, so you need to be thinking about whether you satisfy that criteria. So people need to be furloughed between the period of the 1st of March and the 31st of October, and they need to be continuously employed until the end of January 2021. There's also some requirements in respect of their earnings. Employees must earn at least £520 per month from the 1st of November 2020 to the end of January 2021. You need to check whether you satisfy those requirements to see if you're eligible. Then need to think about whether that's something which is going to help you retain jobs before you think about any other options. So it's hopefully a good option for employers. It gives you another route potentially, but you probably do need to do some number crunching there to work out how viable it is for you. Another thing just to briefly mention is the Kickstart scheme, which is aimed at providing high quality jobs for young people. And as it says on the slide there, those are generally thought to be the highest risk of long-term unemployment as a result of this pandemic. So the government have introduced these measures to help those more at-risk groups. And what that is in respect of 16 to 24-year-olds, their funding costs in respect of 100% of national minimum wage for 25 hours per week, plus national insurance and pension contributions for 6 months. So it's quite a good option if that's something you can afford to do and you can accommodate in your workplace. So do have a look at that, and again, do that number crunching to see if that's something you can do to save jobs, create jobs, as opposed to looking at other options. There's also some new schemes in respect of apprentices and trainees available from the 1st of August until the 31st of January 2021. And that's in respect of funding towards apprenticeships. And it depends on the age of the apprentice, but there's some funding there which can be up to £2,000. There's also some funding available in respect to trainees, which is up to £1,000 per trainee. So again, have a look at that, see if that's useful to you. Might be a way that you can avoid perhaps more draconian options. I'll just remind you quickly, we're getting some really good questions through, but please do continue to post your questions on the question and answers facility. We'll answer those questions best we can towards the end of the session. We've got a number of questions that have already been previously posted to us, and we're going to get to those at the end as well. As I say, keep posting them and we will answer them right at the end of the session. So returning to work is the next section I just wanted to cover. So the new buzzword we've all heard about is COVID secure. So we've had enough of Brexit, had enough of GDPR. The new buzzword in the employment law is COVID secure. All businesses need to be COVID secure before they reopen. So what does that really mean? So it really means carrying out risk assessments and making sure you're doing everything you need to do to make your business, make the workplace as safe as possible for your employees. Now, it doesn't mean you have to avoid all risk altogether. You can't do that. It's not possible to minimise all risk altogether in respect of COVID. But it does mean you have to take reasonable steps insofar as practicable to make sure the business is secure for those employees. That may be things like social distancing in the workplace, PPE if appropriate, washing hand facilities, all of those sort of things you need to be doing. And I'm sure all of you are thinking about those things and doing those things already. You need to do that before you reopen. Many of you will be reopened already. You would have been open throughout this. But in terms of reopening, what I'm talking about is opening in terms of allowing people back into the workplace as opposed to working from home and continue to work in that regard. So you need to be doing all those things, think about bubbles, and so carrying out those risk assessments, which do require you to consult with staff and explain to them what you're planning to put in place and get their views on it. And there's various legislation that's relevant there that you need to be taken into account. Again, if you're not sure what you're doing there, get some legal advice on it. It's a fairly complex area of the law, but there is lots out there in terms of that can help you with it. There's lots of government guidance. There's the health and safety guidance from the health and safety executive. There's also guidance in the education sector from the DfE. So just be aware of that guidance, make sure you're following it best you can, and then get that input from your employees. You need to understand what their concerns are and try to address those best you can. So you're only going to be able to do that through proper consultation. There's no sort of set timeframes in respect of consultation. It generally needs to be done in good time, and ideally you need to be reaching agreement with staff. There are some probably more onerous obligations if you have trade union obligations, a trade union involved at your workplace. So obviously be aware of those trade union obligations as well. And collective consultation needs to be considered if you're at those sort of numbers. So I'm sure most of you are doing that all already, but it is a really important step, and having done proper risk assessments and consultation can help you if you are dealing with particularly problematic staff and those refusers who are refusing to come back. That's what I wanted to cover off just next, is how you deal with those refusers. And I guess the starting point is that you need to find out why they are refusing, what is their issue in terms of coming back to the workplace. And then from that, you can work out where you go from there. Can you just discuss it with them and resolve it by explaining the steps you put in place to try and maximise their health and safety and protect their health and safety in the workplace? Can you explore other options with them? So it may be that you can continue to facilitate working from home with those refusers, maybe look at annual leave, other types of leave, unpaid leave. Furlough may be another option you can consider with those particular individuals. So do think about all those options. It's probably best to get some legal advice if you're not sure as to how to deal with a particular individual who is refusing, because it would depend on the specific circumstances, but there are options. Probably the final option that you might need to be considering is dismissal if you are having somebody who's absolutely refusing and you have got good reasons why it's not reasonable for them to refuse. However, there are some inherent issues and risks in respect of potentially looking at dismissal of an employee on health and safety grounds. That moves us on nicely to the next slide. So there's a right under the Employment Rights Act 1996 in respect of unfair dismissal and detriment for people who are raising concerns about their health and safety and are potentially dismissed as a result. So the right is for employees not to suffer detriment or dismissal in circumstances of danger that the employee reasonably considers to be serious and imminent. And as a result, the employee leaves the place of work, refuses to return to the place of work, or takes other appropriate steps to protect themselves and others. Now, there's a couple of things just to point out in respect of that right. The first is that the first bit that's highlighted in red, circumstances of danger. That is an objective element of the right. So there needs to be objectively circumstances of danger. However, the next bit is that the employee reasonably needs to consider them to be serious and imminent. Now that brings in a subjective element to the test. So the employee's subjective assessment of the seriousness and imminence of the threat and the danger is taken into account in respect of that legal right. So that really comes down to, shows the importance of you understanding the employee's concerns and whether they are reasonable and trying to resolve those with the employee. So your risk assessment, the measures you put in place in terms of bubbles, social distancing, sanitising, everything else, all will help demonstrate whether that subjective test it has been met by the employee. So if you can prove that actually you've done all those things and it wasn't a reasonable assessment for the employee to take, that will absolutely help you. Again, just reiterate that if you are getting employees who are in a position where actually you need to think about taking some action, which may include dismissal, it's definitely worth getting some legal advice before you take that step. I would just say that because this area of the law is fairly untested. There's not a lot of case law in respect of health and safety dismissals. And the case law we've got is in situations which are not necessarily that similar to the coronavirus pandemic. this is a new area for everybody. And what we wouldn't want you to be is a test case in respect of this kind of claim. So do get some legal advice on it. It is unprecedented, and we don't know exactly how the tribunals will, what side they would take in respect to these sort of claims, and what evidence they will need to establish that the employer has taken, what steps they're taking to minimise the risk on employees, so actually their stance is not a reasonable stance to take. So I just flag that to you. Just do get some legal advice before that you take that step, but it is a potential outcome that you can consider if you have got a particularly stubborn employee who's not refusing to return and the reasons are not particularly valid. I would say that take that with a pinch of salt, because obviously some of the reasons will be very valid concerns, and you obviously do need to make sure that you accommodate those as far as possible. But where they are not valid, I'm sure lots of you will have those kind of individuals as well. There are things that can be done, but it is worth getting the legal advice on it. Just one more thing just to flag, and that is just mentioned on the slides, is that danger in the context of this right is wider than a feature of workplace and can come from other people. So this is why we think obviously the coronavirus situation will bite, because anyone they're in contact with at the workplace or in travel into the workplace could result in a situation which is deemed dangerous. I hope that answers your questions on that. So we've got some more time for questions at the end of the session. So I'm trying to answer questions in the context of what I'm saying, but there will be some time allocated to specifically answer the questions that you're raising and have raised at the end. One thing just to mention is about quarantines. It's a fairly new thing which is obviously rearing its head now. We've got people travelling abroad to their holidays. As we know, if you're travelling to Spain and various other locations, on your return, you do need to quarantine for that limited period. So what do you do about that in respect of your employees who have gone abroad and booked holiday and are intending to travel? And the first thing to say is obviously you can't stop employees who put their holiday in taking their holiday and using it as they wish. But you can certainly, as the employer, make them aware of what will happen upon their return. So that may be that they can continue to work from home if they're working from home, but if they are meant to be back in the workplace and it's not possible to work from home, that may cause more problems that quarantine period. It would depend whether you have to pay them with their quarantine during periods of quarantine. Would depend on what they can do and what their specific situation is. If they are sick upon return from holiday, then it may be that sick pay bites in that situation. But if they're not sick and they are just quarantining in respect of that period of being abroad in accordance with the government guidance, then you may not have to pay them. It would depend on what your policies say and what your procedures say. I very much doubt your existing policies would talk about quarantine and what you have to pay there, but you obviously need to consider those in the context of deciding what they need to be paid. But if there is no contractual entitlement to be paid, it's likely that their period will be unpaid in respect of quarantine. So that may deter people from thinking about travelling abroad and considering other options. So do make them aware of that as well and have those discussions. Again, if you're having some difficult discussions with employees and not sure how to handle those, please get in touch. We're more than happy to help you as to how to resolve those issues. So it's likely to cause more problems where you've got people who cannot work from home as opposed to people who can work from home. We've got some various articles and pastorals on that particular subject. So if you're interested, again, sign up to our coronavirus hub. You can access all those articles and all the detail around those and our sort of thoughts on those subjects. So moving on from health and safety and quarantine, we're going to look just briefly at return to the workplace and changes to terms. Now, many of you may be in a situation where you cannot accommodate people returning to the workplace as they did previously, outside of furlough I'm talking about. So say actually, as a result of furlough, you determine that you don't need people on quite so many hours, or you need some changes in respect of duties, or other changes to their contract as it was prior to the COVID situation. there's some things you need to think about when you are changing those terms. Firstly, you need to think about what rights you've got under their contract to vary those terms in accordance with their contract and following those requirements. You may have a clause which gives you some scope, some limited scope to make changes. Most of the time, however, it's still sensible to take other steps when putting through changes to contracts. Generally, the best way to proceed is to get an employee's agreement to the change through consultation. And I'd say that even if you have got those clear express contractual clauses in the contract, generally it is still best to get that agreement, because there's always a bit of argument and a bit of room for wriggle room for argument where you have got a contractual clause and solely rely upon that. And as the employer, you obviously still need to be acting reasonably in accordance with that duty of trust and confidence. So generally, consulting with staff and trying to get their agreement is the best way just to proceed to ensure that you are acting in accordance with that duty of trust and confidence. There are some other options which you can consider if you are looking at changing terms and conditions and you can't get people's agreement. Probably the least recommended option is to unilaterally impose the changes. Generally, we recommend that you avoid this option because that can result in claims such as breach of contract and also constructive unfair dismissal claims. So that is probably to be avoided if best possible. The alternative is try and consult with staff, you try and get their agreement, but you just fail to get that. You could potentially look at dismissal and re-engagement. Now that is still a dismissal at law. So if employees have the requisite service for unfair dismissal, it could result in a claim there, but you may be able to defend that claim and show a fair reason for dismissal, depending on the basis upon which you're changing the contract and the commercial need. So again, it's probably worth getting some legal advice around that if you are thinking about the dismissal and re-engagement option, but it is an option and employers do frequently use it to try and get a result where you're getting a situation where there is pushback. A lot of the best way to kind of get an agreement to changes is communication. So explaining to employees the importance of why you need them to agree to this and what the outcome could be if they don't agree to it. You may find that gets their agreement. So if there are more draconian options which may need to be considered, if you can't get people's agreement to some variations to their terms, mentioning those is often important, but doing it in the right way. Collective consultation is something else just to be aware of if you are thinking about varying terms. If you've got 20+ employees who are varying their terms, where there could potentially be a situation where you have to dismiss them and re-engage them, collective consultation is necessary, and generally it's best to do that at the very outset. Now, that's not always done and there are some risks in respect to that, but again, if you're thinking about changing terms, particularly where you've got large numbers, get some legal advice and we can advise you on all the options there. And that's all I've got to cover at the moment. Sarah's going to talk about redundancies as the next subject, so I'll pass over to Sarah now. So please keep asking your questions. We'll answer those best we can towards the end.
Fantastic. Thank you, Charlotte. Morning, everyone. So, yeah, as Charlotte's talked about, we're looking at potentially people coming back to work, and so that might involve looking at changes to terms and conditions, but it might also, unfortunately, mean looking at some redundancies. And we are seeing a number of businesses in a position where they need to consider making redundancies. And that's due to a number of reasons. Some, unfortunately, workplace closures where businesses are just closing down. Some in respect of reduced workload, and some of them actually half positive because actually it's just a more efficient way of running the business where people working more centrally working and kind of better systems. So there's lots of reasons out there as to why businesses might now be needing to restructure and look at how to change their business. So just covering off what redundancy is under the Employment Rights Act, just as a brief reminder. So in order to fairly dismiss someone where they have close to or over 2 years service, you have to have a fair reason, and redundancy is a fair reason as long as it is genuine. So there's 3 scenarios in the Employment Rights Act as to when you can make redundancies. And the first 2 fairly obvious as to whether or not you are. So where an employer ceases or intends to cease carrying on a business in which the employee works. So the business is closing. The second, where you cease or intend to cease carrying on a business in the place the employee works. So that's purely geography. Is the office closing? Is the particular place of work closing? The third is the one that we actually see more frequently. So where the business needs fewer people carrying out work of a particular kind. And that's definitely the kind of harder scenario sometimes, because it's not always just a reduction in the number of people. You've got 5 people doing one job, you actually only need 3. It can be other kind of reasons as well. So some of those might be where old skills are being replaced with new skills, such you just need a completely different skill set for a role because of advances in technology, etc. Where the same output can be achieved but by less people, and where you need fewer employees because actually you might be looking at a different way of working in terms of using agencies, independent contractors, etc. So that's the quite tricky area, and that's often where we get asked for the most advice, and always sensible. If you're not looking at sort of workplace closure or business closure, actually just getting some advice around work of a particular kind and the reduction in that, because it can be a very fine line between that situation being a redundancy or it being a change to terms and conditions, in which case, whilst the process is fairly similar, you would need to think about whether the individual is entitled to a redundancy payment. So then moving on to briefly look at the process, because there's lots we could talk about in respect of the process in a whole separate webinar. But process is really key, particularly if you want to try and minimise the risk, again, of unfair dismissal claims. And really be thinking about this, even if you've got individuals with less than 2 years service, because if you've got a number of individuals that you might be considering making redundant, if you don't do a process with those with less than 2 years service, it could actually impact on the wider process for your other staff that do have more than 2 years service. So be really careful about that, and it may mean that you actually need to go through a full consultation process with everyone, despite the fact you might have some slightly easier wins in terms of people with less than 2 years service. But what does that look like? Well, ultimately, we set out the steps there, but a kind of general redundancy process includes that warning at risk consultation meeting, consulting with individuals either individually or collectively, depending on the numbers involved, thinking about how you're going to select them. So are we talking about standalone roles where maybe they form a pool of their own, or are we talking about a pool of people who are doing the same role or they have similar skills where you will need to pull them and apply a subjective selection criteria to them? So think about that as well. Consideration of potential alternatives to redundancy, so absolutely key in a redundancy process. Redundancy must be the very last resort. You need to consider alternatives as well. And that can also include a really weird concept known as bumping. Again, it's something we advise our clients on quite a lot, because in effect, what bumping says is, as an employer, even if an employee doesn't raise it, you must consider whether individual A, who you're proposing to dismiss, could be bumped and put into another person's position and then make employee B potentially redundant. Now, in most cases, employers will consider it, they'll have reasons as to why they don't necessarily think it's appropriate, and those should be documented. That might be the end of it, or you might need to consider it further if an individual raises it. It's a really weird concept, because in effect you're saying, I'm at risk of redundancy, I'm going to push someone else out instead. So it is quite rare that employees really push for it, but it is something to bear in mind, because that you can really get caught out in respect of bumping. Thinking about other alternatives, so are there suitable alternatives in the workplace in terms of jobs? Even if there's not suitable alternative, i.e. jobs that are very similar level of pay, do you actually have any other vacancies that the individuals would be interested in? Because ultimately you're trying to avoid this redundancy. Just on collective consultation, we won't cover it in too much detail, but where you're proposing to dismiss as redundant 20 or more employees at one establishment within 90 days, then you need to look at collective consultation as well. And there are obviously certain timeframes in respect of that we'll look at a little bit further later on. The final point, just on the general process for redundancy, is thinking about appeals. So for redundancy processes, they're slightly different to disciplinary and grievances. For disciplinary and grievance procedures, you have the ACAS code of conduct that you should follow, otherwise it can impact compensation, etc. They say you have to allow an appeal for a disciplinary or a grievance. However, there isn't a code of conduct for redundancy. So technically speaking, an employer doesn't necessarily have to offer an appeal at the end of a redundancy process. Generally speaking, it's best practice too, and we always say potentially it's worthwhile doing, because you've given the employee an opportunity to flag if they're not happy about something, if they want to challenge something. And it's often far better to know that at this stage than it is when you get a claim land in your lap. However, there are some downsides to it. It can lengthen the process, it can make it more difficult, and if you've already made some other people redundant, it could impact your wider process if you started offering appeals. So again, that's where it's really sensible actually just to get some advice, just to sense check that, just to talk through the pros and cons, because in certain circumstances, it might be better not to offer an appeal, because actually for your wider process and how you're dealing with things, it might be better. But generally speaking, it's always safer to offer an appeal, because you're very unlikely to be criticised for offering an appeal, whereas you may be criticised for not offering one. So then having a look at redundancy and furlough. So we're getting lots of questions from clients about this, and it's something we're seeing kind of lots of questions over. During furlough, even flexible furlough, in terms of when the staff aren't working and they're on furlough, what do you do about redundancy? Can employees participate in a redundancy process while on furlough is one of the questions we see an awful lot of. And that includes either individually, where you've got individual consultation, you're talking to them directly, or acting as an employee representative. The guidance is a little bit unclear in respect to this, although it's much clearer in respect of if you're acting as an employee representative. But we do believe, from what the government have put out there, and also from commentary, that you can consult with staff, so individually or where they are appointed as employee representatives for a collective consultation process. So definitely they're not providing a service, they're not contributing revenue to the business, you are actually talking to them about their job, their role, and whether they will stay in the business. Now, just be conscious that obviously if you do have to collectively consult, and as I discussed, it's where you're looking at making potentially 20 or more people redundant, that can include where you're changing terms and conditions, then you've got this obligation to collectively consult. For 20 over up to 99 employees, then you have to consult for 30 days prior to your first dismissal. And for over 100 redundancies, it's 45 days. And that's in a longer period as well. So be careful with staggered redundancies as well. So what does that mean? Well, actually, if you are planning ahead, we all know the furlough scheme's coming to an end in October. If you think there is a chance you might fall into those collective consultation brackets, you probably need to be planning sooner rather than later. And so whilst people were concerned about consulting for redundancy under furlough, it is actually much better that you at least start your preparations for that in your plans, and if not, actually start the process itself. Because ultimately, you probably need to start consultation no later than middle of September, where you're looking at making over 100 redundancies, and no later than start of October, where you're below that number but over 20. So time is ticking away, and you will need to start thinking about those things. Particularly because collective consultation, the time frame doesn't actually start to run until after you've elected representatives, if you haven't already got representatives or unions in place that are authorised to collectively consult on redundancies. So that's going to take you a bit of time sorting out the election, particularly because you're working remotely, but also until you've provided certain initial information to those representatives as well. And dealing with collective consultation at the moment is going to be trickier, because ballots are supposed to be held in secret. So you're going to need to think about how you deal with that, where you've got a virtual workforce at the moment, making sure you've got enough representatives. So actually, if you are thinking that you might have larger numbers of redundancy, really start getting those plans in place now. You also obviously need to notify the Secretary of State if you are making proposed redundancies of 20 or more as well, and there are criminal sanctions if you fail to do that. So again, a really good reason why you should start planning if you do think there may be a need to make some redundancies. So do you have to take into account furlough as well when you're looking at making redundancies? So even if you have a genuine redundancy situation, and I'm sure there are many genuine redundancy situations out there at the moment, unfortunately, you do need to think about alternatives to redundancy. And some of the arguments that we are seeing from people is, well, couldn't you just keep me on furlough? Keep me on furlough for another month or two, see how the business is. If the world gets slightly more back to normal, then there might be more work and you might not necessarily need to make me redundant. That is something that you should consider, definitely. Even if the employees don't raise it, you should consider whether that is an option. The fact that employers are now having to contribute towards the furlough scheme is actually probably helpful, because if as a business you genuinely can't afford to contribute towards that scheme, then that may be a reason as to why you say to employees, actually, we've considered that, but we genuinely can't afford to do it. Whereas if you can afford to do it, it may be an option to bide a little bit more time. It doesn't mean you can't make dismissals, but you certainly need to have given it some consideration and have business reasons as to why you're turning that down if you do turn that down. So then, ultimately, you do need to be a bit careful, because although we think that you can turn down the argument about staying on furlough, particularly now that costs and contribution towards those are coming in, we haven't had any of these really cases tested in the tribunals for now, and it's likely to be in the coming years that we see those being tested. So one, you probably don't want to be a test case, but two, we think tribunals are probably likely to want to try and help individuals, try and find a way to kind of help them, because there's lots of people that are ultimately going to be out of work. So again, it's an area where if you're going through a redundancy process and potentially furlough is an option to not making people redundant at the moment, getting some advice around that to talk through the pros and cons and how to deal with that when it's raised, and clients have said have been invaluable in terms of helping their processes. So just something to think about. So then if we move on to look at redundancy and notice pay and the grant itself. So can you use the furlough grants, the job retention scheme grant, to contribute towards redundancy payments and notice pay? So the guidance makes very clear that you can't use the job retention scheme, so the grant, to contribute towards redundancy pay. So if you're making redundancies and individuals have close to or over 2 years service, they'll be entitled to at the very least a statutory redundancy payment, if not a further payment if you offer enhanced schemes. And you cannot use the furlough grant to contribute towards that. So you as an employer will have to foot the bill for that. In terms of notice, the position has been made a lot clearer, which is helpful. So our understanding now from the guidance is that you can use the grant to contribute towards notice pay, but only where the individual is serving out their notice, albeit that they obviously remain on furlough, because if they're working for you, they wouldn't be unless they're doing flexible furlough. But ultimately, if they're serving out their notice period with you, then you can use the grant to contribute towards their notice pay. If you terminate their employment and pay them in lieu of notice, then you cannot use the grant towards that. So something to bear in mind when you're thinking about notice and what to do with notice. There may be circumstances where it's better to pay in lieu if someone's getting close to 2 years service and you kind of want to minimise the risk of extra claims, etc., but just one to be aware of. We've then been asked a lot of questions about, so how should you calculate notice? Obviously, these individuals have been on furlough potentially for a long period of time, receiving 80% of pay. How do you calculate that notice? Is it based on their normal salary or their pre or on their furlough salary? And the government's actually now introducing legislation. So it's the Employment Rights Act 1996 Coronavirus Calculation of a Week's Pay Regulations 2020. Very catchy headline. And that's now enforced to prevent employers from paying notice at furlough rates, because some people were abusing that system slightly. It's in place. The rules, as ever, because they've been rushed through, are quite complicated, but essentially the safest course of action, and under these regulations, it essentially means that employees should generally receive their normal pay, which is their pre-furlough pay, so their 100% of pay during their notice period. So the safest course of action, if you just want to minimise the hassle and risk of people arguing over this, is to probably pay staff your 100% pay. Obviously, if they are still on furlough during their notice period, you can then claim the 80% towards that, albeit that for August, September and October, you'll have those contributions that you then need to make towards it. But you're just topping up pay as opposed to paying the full 100% yourself. However, you might be able to base notice on furlough salary. And that's generally where, if an employee is entitled to at least 1 week's notice more than the statutory minimum, so the statutory minimum is 1 week for each year of service. If they are entitled to more than 1 week on top of that, so they're getting a much better notice period than statutory, then potentially they can receive their contractual rate of pay for each week. And so arguably you could say that their pay has been varied in accordance with furlough. And so you may be able to try and argue that they should only get their furlough pay. It works in a similar way if they've been off sick or if they've been on maternity leave or something like that. However, it's still not massively clear and it's probably risky. So if you were looking at potentially looking to pay less during their notice period, again, it's probably sensible to get some advice on it, because if you're talking about a number of employees, that could get quite costly if you get that wrong. If employees are only entitled to statutory notice or less than 1 week on top of that, then you have to pay that at full pay. So just something to bear in mind in terms of how you deal with notice. You're also going to want to be clear about what happens with furlough, etc. on termination. So then just moving on to some redundancy do's and don'ts. It's really there more just as a reminder, all things that hopefully you're all aware of and all doing anyway. But do listen during consultation, consider what's being said, take breaks, record accurate minutes of the meeting. Really, really important. I know it's difficult, but recording those minutes will really help. Be sympathetic and making sure that you're involving HR in that process. And really importantly, making sure you're consulting at the right point. So that is before a decision has been definitively made. Because if you just make a decision, even if it includes a closure of a business, if you are decided that is going to happen and there's no budging room on that, you're likely to fall foul of the consultation, because it will just be, ultimately it's futile. You don't really have a reason to consult because you've already made the decision. So just being really careful around that. It has to be more than just a proposal. So if you're just thinking you might close a workplace, for example, you don't necessarily need to consult at that stage. But once it becomes a bit of a firmer plan, but without being ultimately decided, you need to start thinking about consulting. So don't make any predetermined decisions as well. Really be open. Staff might come up with some really great ideas how to try and help the business. So don't go in this with a very negative attitude. Listen to what staff have got to say if they've got any great business arguments or reasons or ideas and suggestions. Answer questions, but if you feel uncomfortable to answer them during the process, go away, think about it and come back to them. Discuss outcome internally in advance before you write them as well. Always best to do that. And don't make a decision until you're sure and you've kind of understood the whole consultation process. So just a few kind of reminders there on what to do and not do for redundancy. So on a more positive note, hopefully, lots of businesses out there where actually redundancies won't be necessary or will be minimal, and you've got a workforce who are now hopefully set up to work very flexibly and in a very smart way. And we've seen with lots of clients, lots of our contacts, etc., that COVID has actually advanced their plans. So they were planning on smart working, agile working, maybe looking to aim to do that in the next year or so. Massively brought forward their plans because it's had to, and it's really made a great environment to work in. Businesses are working much more flexibly, being very adaptive to the situation. So what does that mean? We're probably actually thinking about, can your staff continue to work flexibly? We're seeing lots and lots of individual businesses where they're saying, actually, this is working. It's giving people more time because they've got less travel. So actually, it's a really positive thing to consider. So what do you want to think about? Well, everyone potentially moved to this home working or remote working quite quickly, and so may not have been set up for it. Other businesses, potentially you've got those working from home policies in place and the contracts are set up, etc. But still worth looking at them, because when did you last look at them? Are they up to date? Do they need amending? And there's a lot of things you'll want to consider about people working from home. So health and safety and making sure you're carrying out workplace and desk assessments, etc. How you're going to deal with keeping in contact and setting your clear expectations. We're in a world at the moment where people aren't necessarily working 9 to 5 because they've got childcare responsibilities and other responsibilities. So actually, do you need to shift from that 9 to 5 attitude to delivering a certain task or project attitude, where you almost don't mind the hours as much as long as the job is done? And shifting that can be quite difficult, but thinking about that sort of outcome rather than the time spent on it or the exact time spent on it. Looking after mental and physical health, it's quite lonely working at home. I know I certainly miss the social interaction of seeing my colleagues in the office. We have lots of Teams calls and calls daily, but it's still not the same as being in an office and seeing people. So making sure you're kind of dealing with that, but encouraging regular breaks. It's really easy to sit at your computer from, you know, whatever time in the morning to whatever time in the evening without really getting up and walking around and having breaks. And then thinking about things like equipment and technology, how you're going to deal with that remotely if people have issues with it, whether you kind of have rights to access, you know, that if you need to go and pick it up or collect it, because ultimately people are now in their homes and they could refuse you access. And also thinking about other outside the box points such as insurance, you know, are they insured? Does the insurance cover them working from home? Even things like, are they actually allowed to? Because some restrictive covenants in relation to property documents and deeds sometimes say you can't run a business or work from home. So making sure that staff are checking that. And just being really careful around sensitivity and flexibility. What are your staff doing? Do you need reasonable adjustments for people? If you've got people that are ill, that have a disability, then looking at making those reasonable adjustments, but also childcare. Number of people obviously working at home at the moment where children are around. Hopefully that will get better in September, but ultimately it's a challenging world. I think on most phone calls that I've been on recently, at some point a child has popped up somewhere. So I think everyone's mentality to that has changed, but just being conscious of that and really making sure you've updated your contracts and your policies. Another question that we sometimes get is, does the fact that people have been working from home mean that they now have the right to? And I think as long as you've been clear that this working from home at the moment has been due to COVID, then it's likely to be a temporary change to their terms and conditions. But if you haven't been clear, you'll want to make sure that you're thinking about that. Otherwise, someone might be able to argue that through custom and practice, they're now permitted to work from home. So it's good to be talking to your staff and thinking about this. But if we move on to looking at flexible working requests, and I won't cover this in too much detail, but ultimately employees have a right to request flexible working formally if it hasn't been discussed informally. And I've set out on the slide the rights in respect to that. So you have to be an employee, you have to have at least 26 weeks continuous service and not have made an application in the last 12 months. And the change could be in relation to lots of things. So how many hours they work, you know, their start and finish times, when the work's done, where it's done. So lots of different reasons as to why it can be requested and what it could cover. When you receive a flexible working request, if we move on to the next slide, the request has to include certain information, and that's the fact it's a request for flexible working, has to specify the change that wants to be made, etc. And on this slide, the top of the section shows what has to be on there. And there are these 8 reasons that a business can refuse flexible working requests. And this is the formal flexible working request. And just as a reminder, it's a right to request, not a right to work flexibly. These are quite easy, or previously have been quite easy to turn down. So from a flexible working application perspective, it's quite easy to turn down a flexible working request, or historically has been. You have to be a bit careful if it's for childcare reasons or something like that, because there could be indirect discrimination claims outside of that. However, now that everyone has been working from home, if that has been working and you get a formal flexible working request, it is going to be quite difficult to now turn those down, and you're going to have really good business reasons as to why. So getting some advice there would be good, because ultimately people have been doing it, it seems to have been working well. So just bear that in mind as well. So that was all I had to say on those few bits in terms of flexible working and redundancy in respect of returning to work. And we're now going to move on to question and answer, because we've had lots of really great questions. Please keep asking them if you've got questions. We'll try and fit in as many as we can. Otherwise, we'll make sure we follow up with you after the session. I'll hand over to Laura to hit us with the first question.
Thanks, Sarah. So, first question. Do individuals still have to be on furlough as at the 31st of October in order to be eligible for the job retention bonus, or are they eligible for the bonus if they have been furloughed at any time during the scheme?
I can answer that question. So it's if at any time during the scheme they've been on furlough, you are eligible to claim that job retention bonus if you are getting people back. But then it's subject to those various requirements in respect of their return. So whether they're returning beyond the 31st of January, and their earnings being a certain amount. So subject to those conditions, yes, at any time they need to be furloughed, not the whole time.
Thanks, Charlotte. Next question. If you did not furlough staff under the original scheme, can you not use the flexible furlough scheme?
You need to, I can answer that question as well. So you need to have furloughed them for the 3 weeks prior to the end of the scheme to be eligible for the flexible furlough scheme going forward. So if you didn't furlough people previously, then you would not be eligible for the flexible furlough scheme, subject to the exception in respect to those people returning from family leave. There is an exception there.
We've had a couple of questions about public transport and employees being kind of reluctant to return to work because they don't want to use public transport. People have been asking, what are their options? Are they obliged to pay for taxis? What are the kind of things that they need to consider?
Yeah, I'm happy to answer that one. So in terms of dealing with that, I think you're really going to have to get to the bottom of why. So typically speaking, transport isn't something that's included in a workplace assessment, but we think because of COVID and the issues around that it's likely to be, and you should really be covering it off. So I think the first port of call is to really understand why. If it's because someone's got a medical condition, then it might be a reasonable adjustment to consider alternatives. If they haven't got a medical condition but they're worried, then you have to be careful around the health and safety laws, like Charlotte talked about, because potentially if someone genuinely feels that there is a risk and they're punished for that, there could be some issues. But I think exploring why they need it and then exploring alternatives. So can they travel at a different time of day? So actually, could you change their hours for a while so that they travel at quieter periods of the day? You know, is there another way that they could come in? Could they work from home, or is there somewhere more local that they could work? Ultimately, if they are really concerned about it, or they've got health issues, you might need to consider whether you do have some form of transport, such as taxi, etc. It's not an obligation unless it's a reasonable adjustment, but you'd want to just be a little bit careful. If they're just being difficult, and actually you've suggested lots of great alternatives, but they won't agree to those, you've probably got a better position to say no. But I think really getting to why they're worried about it, and seeing if you can find a way of working around that.
Thanks, Sarah. So we've got a question on changing terms and conditions. If it's a favourable change, like a promotion or a salary increase, does the employee have to agree to that? Can the employer just send them a letter, or does the employee actually have to sign to indicate their agreement?
Probably in respect of a favourable change, you can get away with just sending them a letter just to confirm the change that's going ahead, and then them receiving it is their agreement essentially. Belt and braces, always get them to sign something just to acknowledge the fact that they accept that that is the new contractual arrangement. So that is to the belt and braces approach, but no, not as risky in respect of the favourable change. The risk is greater in respect of an unfavourable change.
Thanks, Charlotte. Next question. Can you consult with staff now and agree a redundancy will happen at the end of furlough? And would you need to use a settlement agreement in that context?
So I can tackle that one. So yeah, those collective, if you're talking about collective consultation, for example, they are minimum timeframes that you have to do. So there's nothing to stop you doing a much longer time frame. The same with individual. There would be some kind of bespoke points to that in terms of notice, because ultimately an employee can serve counter notice. So if they're entitled to a certain period of notice, if we take out collective consultation for now and we talk about individual, if an employee is say entitled to 2 weeks notice and you actually try and give them 2 months or something like that, they can actually, and it's quite technical, but they can actually serve counter notice to bring that forwards. And so you'd need to be a little bit careful in respect of that, but you wouldn't necessarily need to use a settlement agreement. If you're paying them something extra, some sort of retention bonus, then you might want to think about it. Again, that's probably where it's worthwhile getting some advice in respect of the specific facts, just because we've actually been helping some clients with that, where they need people around for a little while longer, and they want to try and do that positively, and deal with that effectively. So potentially yes, and you may not need a settlement agreement, but it would depend on kind of the individual's notice periods, etc.
I think that's probably all we've got time to answer. So I'm sorry for those of you who haven't got to your questions. We may have answered them throughout the session. For those of you who haven't got back to, if you've left your contact details and your name, we will absolutely get back to you after the session to answer your query. Do make sure you've given us your contact details so we have got those. Thanks very much, Azara, for joining us in the session. We hope you enjoyed it. Any questions you've got further to the session, please again do get in touch. We're more than happy to discuss them with you. I'll just mention the feedback form again to you. So that is available on the question and answer facility. So if you could kindly complete that, it would really help us. But it's not as easy to get your feedback when we're doing these sessions virtually. So completing that form is really helpful for us, and it really helps us shape our future events. So please do feedback back for us. That'd be really helpful. So I hope you've enjoyed it. Got some future sessions coming up in the near future, so do sign up to our coronavirus hub and our mailing list to make sure you get those invites as and when we do future events, and we'll keep you up to date on the latest developments. Otherwise, best wishes, hope it all goes well with your planning and the actions you're putting in place, and we'll hopefully speak soon. Thank you.
Thanks everyone.